Hello, I'm Amanda Moore. Welcome to the Advocacy Exchange for April 2018. The Advocacy Exchange is our monthly conversation with advocates advancing change. Both the Advocacy Exchange and the Clearinghouse community at the Shriver Center love to bring you these conversations every week, and the Shriver Center is a national leader in advancing justice and opportunity. Today, I am joined by Sabrina Forté and Serena Holthe. Sabrina is a staff attorney with the Youth Justice Project at Bay Area Legal Aid, and she's joining us today from near wine country. She's in Oakland, California. Welcome, Sabrina.
Good morning.
And Serena Holthe is special counsel at the National Juvenile Defender Center, and she's joining us today from Washington, D.C., other side of the country. Hello, Serena.
Hi, how are you?
Well, Serena also co-authored this month's Clearinghouse article. It's called Collateral Consequences of Juvenile Court Involvement, an Opportunity for Partnership. She wrote this article with her colleague, Hilella Simpson, and you can find their article at povertylaw.org/clearinghouse. That's the address for the Clearinghouse community. And we're going to talk about those collateral consequences and the opportunity for partnership today. But first, I want to let you know how you can be part of this conversation. We welcome questions from viewers. We would love to hear from you and hear about what it is that you want to know more about. As I've already mentioned, some of you are saying hello on the live chat on YouTube. That's one way to let us know. If you're watching on YouTube, to the right of your screen, there's a live chat button. If live chat is not your thing, that's okay. You can also email me during the conversation. My email address is Amanda Moore, Moore, at povertylaw.org. So let us hear from you. Everyone who registered for today's conversation will receive a follow-up email probably next Monday. That email will contain a link to Hilella and Serena's article. It will also contain a link to a recording of today's broadcast, as well as a link to register for next month's Advocacy Exchange. So keep your eye on your inbox for that. Without any further ado, let's get started. So some people might find the whole idea of collateral consequences from juvenile court to be strange. I think a lot of us are under the impression that juvenile court is sort of like Las Vegas. What happens there stays there. But I'm gathering that that is not the case. So, Serena, how is it even possible that youth who have been through the system can be affected by a juvenile record?
And actually, a large majority of states, juvenile records, at least some juvenile records, are available to the public. So whether it's arrest records or court records, those records could show up on background checks. They could show up in a credit report in some way. Sometimes these records actually even show up through the DMV. So there's many ways in which people can actually find out about juvenile court involvement through the access of records.
Well, I'll stay with you for a minute, Serena. So what are some of the examples of ways that youth could be harmed? What are some of these collateral consequences that youth in particular may face because of these records?
I think some of the most unique collateral consequences when we're talking about young people is especially in education. Young people in many different states can have, state actors, let's say probation officers or court personnel can notify, or police can notify schools if a young person has been arrested, charged, or adjudicated for any offenses in delinquency court. So the school is notified, and now the young person is oftentimes targeted as being the bad kid, the kid who's they have to keep an extra eye out to make sure that they're not causing trouble. They also are often young people who can then have extra problems with special education needs. Often the research shows that young people in the juvenile court system have a higher percentage of needs for special education services, but they're not getting them. And that, combined with the fact that they may have juvenile court involvement, means that these young people will be more often targeted to be expelled or suspended from school or otherwise excluded from normal school activities. Another example is sentencing enhancements. Juvenile adjudications can be, in many states, considered for sentencing enhancements. There also can be, juvenile adjudications can be considered in denying a young person housing. Public housing can take these into consideration if they have to do with drugs or violence. A lot of times people will just think, oh, these are only consequences that apply to adults. But actually, many of the same consequences that apply to adults with criminal records apply to young people with juvenile adjudications. And we're just trying to help make sure that people understand that these are real problems happening to real kids. And we want to bring more success. We want to break down these barriers so that young people can successfully transition to adulthood and have as few barriers as possible.
Well, thank you, Serena. Sabrina, I'll turn to you now. So I think most of us know now that criminal justice issues are intimately tied to racial justice issues. And I'm wondering if there's a similar connection with the juvenile system.
Absolutely. All of the collateral consequences that Serena just described directly implicate the large body of research around disproportionate minority contact, which basically stands for the proposition that individuals of color, here, youth of color, at any decision point in the juvenile justice system exceed their proportion in the general population. To pull out one statistic, a point in time count taken on a national basis, although young Black youth represented 15% of the general population, they represented 31% of all youth arrests and 40% of all youth who were confined. The way that this implicates our work around collateral consequences and civil legal aid partnerships is that these youth often also face unnecessary entry and deeper movement into the justice system, often because of implicit biases about their ability to access community-based programs in lieu of confinement and their community's ability to provide them with the resources they need. The resources are often there, and legal aid and defenders often work together to identify what those resources are, but implicit biases about our youth and the communities that they come from often prevent them from receiving the services that they need and the reentry supports that they need to avoid collateral consequences.
Well, thank you. Serena, back to you. Are there these disproportionate consequences? Do these also fall on other identified populations?
Absolutely. So there are young people who identify as LGBTQ, GNC, lesbian, gay, bisexual, transgender, queer, intersex, asexual, and gender nonconforming that are also where research shows us that they are disproportionately represented in youth who are involved in the juvenile court system. And there was a recent study that came out this past year that's called Missed Opportunities. It was done through the Chapin Hall at the University of Chicago that showed over 50% of young people who were homeless, experiencing homelessness, had connection with the juvenile court system. So we are failing our young people at a very disproportionate rate. These young people are ending up homeless, and we need to start addressing these issues.
Thank you. And I want to remind our viewers that we would like to hear from you. So please let us hear from you either on the live chat with YouTube. We've had a few more people say hello. Chris in Tennessee, Christopher in Florida, and Leslie in Texas. Welcome to all of you. We'd love to hear your questions through the live chat, or you can email me at Amanda Moore, MOORE, @povertylaw.org. So, Serena and Sabrina, the reason the two of you are paired up for this discussion isn't just because your names go so well together. It's that Serena comes from a juvenile defender background and Sabrina comes from the civil legal aid background. And we want to talk about how these two worlds can intersect to benefit the youth that we're talking about. So, Serena, tell us how it is that these two different practice areas can support youth facing the collateral consequences of the juvenile system.
I think that defenders and legal aid attorneys are ripe to become amazing partners to make real difference in the lives of young people. Defenders, juvenile defenders are folks who are representing youth in delinquency matters and should understand adolescent development, understand representing youth and all the aspects of what comes along with that. How to talk to youth, understanding their mindset, understanding interaction. and that how what's going on in their lives is affected by their juvenile court case. They should have a really good understanding of what the collateral consequences are of juvenile court involvement. Legal aid attorneys are great and amazing experts in all the civil legal issues that affect a young person's life, such as housing and education and employment, public benefits. All of these areas, civil legal aid attorneys are experts. We just have not figured out generally as a community, as a nation, how to marry these two, because young people would greatly benefit from both juvenile defenders and civil legal aid attorneys working together. It's hard to probably understand how a housing matter could affect probation and a juvenile delinquency case if they're not talking. If they don't understand, if the civil legal aid attorney who's helping the family with the housing issue is not having that conversation with the defender, if the defender who sees the family having a housing crisis is not connecting the young person with a civil legal aid expert in housing. These are ways that I'm talking about how that we can actually work together, and the expertise of each office can be maximized to get the best outcomes for young people.
So each of you've both partnered with kind of your counterparts in either the civil or the defender world. And I'd like to hear about your experience. So I'll start with you, Sabrina. Can you tell us what your experience has been working with defenders there at the Youth Justice Project?
Absolutely. And to provide some background, Bay Area Legal Aid serves clients in seven counties throughout the Bay Area. And so depending on the level of staffing in each of those counties and the needs of those counties, and also the composition of the defender bar in each counties, we may approach that partnership in a different way. And so I'll pull out two examples and then a couple of through lines between those two examples. The first model is our oldest, that happened about 10 years ago, where we became a collaborative partner in the Alameda County Juvenile Mental Health Court. Alameda County encompasses Oakland, California, and many other cities. And so a lot of our civil legal representation involved civil legal issues that naturally arise when a young person has some sort of high level mental health or other health need, like access to SSI or special education advocacy. Several years later, we were part of the development of the extended foster care program in California. And so our advocacy evolved to also include extended foster care advocacy. To take another example, in San Francisco City and County, we collaborated with the public defender around post-dispositional and reentry issues. San Francisco has a reentry court and a reentry attorney. And so the way that I would describe that representation is working collaboratively with the defender on homelessness prevention for young people coming out of an out-of-home placement, whether that's connecting them with a foster home or a relative foster parent who they can build a permanent connection with, or in finding community-based entitlements that will help them avoid homelessness when they come home. And the two major through lines that I have taken away from our partnerships with defenders is first, there's opportunity for partnership throughout the life of the juvenile court case. So often we collaborate with defenders on reentry issues because perhaps a young person is kind of at the latter stage of their juvenile court case, and the public defender is working in earnest to make sure that their community connections are well entrenched. But what we found is over time, the defenders have asked to bring us in and collaborate earlier in the case to avoid this issue of disproportionate minority contact, diverting young people from the system altogether because there's another community-based system that can serve them that legal aid is familiar with. The other major through line is not going to be a secret to anyone here, which is that the needs of young people in the justice system are vast. And so in working with defenders, we have tried to be as responsive to the civil legal needs of youth as possible, and have had to build expertise, kind of building a plane in the air, building expertise as the issues present themselves, whether that be consumer protection, intimate partner violence, or changes in the laws around fines, fees, or foster care.
Thank you, Serena. Those are really helpful examples. Serena, I'll turn to you. Can you tell us about your experience from the defender perspective?
Well, sometimes defenders have limited ability to take on issues outside of the direct delinquency case. Either it's by statute or by contract or some other means that limits the aspects in which they are allowed to provide representation. Sometimes their insurance, their malpractice insurance limits it. But they are often able to at least handle some aspects of collateral consequences, if it might be sealing or expungement. But as we've already talked about, there's a lot more out there, a lot more collateral consequences, and sealing and expungement just doesn't mitigate all of them. And so we're seeing in the defender world that there is such a bigger need. As I mentioned, the report Missed Opportunities, it points out that over 50% of the young people surveyed who were experiencing homelessness had experience with the juvenile court system. So that tells us that we're missing the opportunity to really make sure they're not becoming homeless. And as defenders, we want them to have great outcomes, not just from the result of their case, but in their lives. And so we need to build partnerships, because we have same probably for legal aid. You're in court a lot. You're very stretched with your time. But I think because of the expertise on both ends, we'll be able to maximize the impact and not increase the amount of time that everybody has to contribute. And so, for example, recently, the National Juvenile Defender Center managed a fellowship program with funding through the Office of Juvenile Justice and Delinquency Prevention. And we had fellows throughout the country. Some of them were at public defender offices, and some of them were at civil legal aid offices. And when those projects were the most effective was when the public defender office had a great partnership with local civil legal aid, and when the civil legal aid office fellows had great partnerships with the local public defenders. And it came to show that this is really how we were best able to address the civil legal needs of young people in reentry. A lot of them were related to collateral consequences of their juvenile court involvement. So for an example, in Richland County Public Defender's Office had an amazing fellow there who did quite amazing work. He worked very closely with their local legal aid office, South Carolina Legal Services, and clinics at the University of South Carolina School of Law. Anytime there was cases that wasn't within his purview, what the funding allowed, he was able to utilize an official referral system that they had created with these entities to make sure that young people weren't falling through the cracks, that they were getting represented. The fellow was providing civil legal services at the public defender's office, but as one person was not able to take on everything. And this was a great opportunity where those young people would not lose the ability to be represented by an attorney, but just was through a different office. And they were able to have amazing outcomes. Young people were being able to get back into school. Like I mentioned earlier, education is a huge problem. Getting kids back to school after an out-of-home placement can require an attorney to be involved, because many schools are pushing these kids out and saying, no, you can't come back. We have an example of a young person that was released from a facility in January and told by their school, why don't you just come back in August? It'll be easier to figure everything out then about where you should be placed. What is a kid supposed to do from January to August and stay out of trouble at 15 years old? It's nearly impossible. And so to get an attorney involved and advocate for that young person to get back into school was essential, because if that kid got in trouble again, they would violate the probation, go back to a placement, and so many other negative things would happen that could possibly prevent the successful transition to adulthood. So by working together, the public defenders and civil legal aid attorneys really had amazing outcomes in regards to education and in housing issues, sealing and expungement. Sometimes one of the offices had limited ability to do the sealing cases. So the Civil Legal Aid Office took that ability on, and they worked together because without the juvenile defenders who had access to the juvenile record information, the civil legal aid office would not actually know whether the young person was eligible to get their record cleared. So without that partnership, they wouldn't have been able to have such amazing outcomes for their clients. And we're not here advocating and saying you all need to do a lot more work. I just think it's really capitalizing and making sure that we are working together with the expertise that we all have so that young people can have better outcomes.
Thank you, Sabrina. And I'd like to remind our listeners that we want to hear from you. We want to hear your questions. You can submit those through the live chat on YouTube. We've had a few more people say hello. Emma in New York City, Nancy in Georgia, and Scott in Texas notes that he's a pastor and he's just trying to understand this issue because he sees it all the time, every week at the food pantry. So thank you for tuning in, Scott. So you've told us about some of your examples of partnerships and the benefits. I'm sure everyone else wants to know what I do, which is how do you make this happen? So it sounds wonderful if you figure out sort of the magic sauce. So Sabrina, how is it exactly that defenders and legal aid attorneys who are both so busy in their own realms, how do they get together to form these partnerships?
Right. There are those rare circumstances when legal aid and defenders jointly recognize that they're serving many of the same young people and come together organically and have the resources to collaborate and conduct a needs assessment and define roles. In the majority of cases, though, we have to be much more deliberate, and in part because there are so many legal aid attorneys in this virtual conversation. I want to push legal aid attorneys to take the initiative to reach out to the defenders in their communities who, as Serena said, identify these issues every single day, but may not have the bandwidth to take on all the civil legal issues that they spot in their client population. And so we've done that in a couple of different ways. Sometimes within our Youth Justice Project, we've had a fellow or dedicated staffing supported through a foundation where that person has a bit of flexibility to reach out to the public defender office and say, let's start some preliminary conversations. Let's take some cases to assess some of the most urgent needs that your clients are facing to kind of get a sense of what a partnership would look like. And we have been able to sustain some of our partnerships through that model. And in other cases, we have actually built formal partnerships funded by a joint funding source with dedicated staffing on both the defender end and on the legal aid end. So in Contra Costa County, which includes Richmond, California, we have partnered on a federal grant through OJJDP, the Office of Juvenile Justice and Delinquency Prevention, to have an in-house attorney who is formerly an NJDC fellow, an in-house attorney at the Juvenile Defender Office who is taking cases mostly around record sealing, extended foster care, and education access, and then working with legal aid pretty much daily to get technical assistance on some cases, to help triage other cases, and to refer cases wholesale to legal aid when they fall within Bay Area legal aid's practice areas, which as I've mentioned, are vast. And so the benefit of having a formal partnership is that there are clear expectations and that there's capacity on both ends to develop those expectations, measure outcomes together. We share data, and we also do community outreach together in furtherance of a common goal. And I guess the only downside is that it does require a lot of advanced planning. We submitted a lengthy federal application together that took some time to know whether we would receive it. And so it does require some advanced planning and deliberation, but it's absolutely worth it to have that kind of formal partnership where both offices are working collaboratively toward ensuring these amazing outcomes.
So how do you make sure that you're not duplicating efforts in the two different offices?
It requires a lot of collaboration and communication between the two offices, and it's varied depending on, as I've mentioned, the composition of the defender office, the needs of the client community, and I think that
Clearly defined roles and expectations are essential, what Sabrina said earlier.
Yeah.
That's the way you make sure. You mentioned some of the sources of funding, and I know that at Bay Area Legal Aid, you have a youth justice project, which sounds like a perfect place for this. Are there other sources of funds that people could tap into other than federal grants? Any other ideas that you've heard about just from around the country?
We have been able to expand our youth justice project through fellowships that pilot new ideas or initiatives. Our youth justice project in and of itself was a Skadden fellowship that brought the idea of dedicated youth services to legal aid in the first place. And we've also had fellowships dedicated to kind of the crossover between the foster care system and the juvenile justice system in California and ensuring parity for foster youth who are on probation. We've also had fellowships dedicated to the crossover between homelessness and the juvenile justice system and intimate partner violence and the need for family law advocacy, especially for survivors of trafficking. And so your typical funding sources like fellowship sources like Skadden or EJW or Soros are really great opportunities for joint applications and coordination and for establishing the need for longer term funding sources. And as I mentioned before, OJJDP has a grant program dedicated to civil legal services access for young people in the kind of the juvenile justice reentry population, a grant that we are in receipt of right now. And hopefully that grant program will continue and expand so that more jurisdictions can serve youth in that population.
Great. Those are really practical, helpful ideas. Thank you for those. And if we have viewers who are interested in this, can I offer you all up as experienced people they can call or email for advice on this?
Absolutely. We would love to be able to support anybody who's interested in exploring these. I mean, they can be as simple as getting your current staff to just start talking. Defenders may be going to legal aid offices and doing a presentation on adolescent development and brain development, or legal aid attorneys coming to defender offices and helping them understand more about the civil legal issues related to this. And it can expand into getting maybe a law student to do an internship at your office and help you focus on this and how to get this started and running and coordinating between the offices, to all the way of being officially funded through a fellowship program. However it could work for your office, we would be happy to help talk through those ideas with you and support whatever actions that you're trying to take to ensure that young people are getting better outcomes.
Wonderful. Well, thanks. And we'll include Sabrina and Serena's contact information in the follow-up email that you should be on the lookout for on Monday, so you can get in touch with them. Looks like we just had a question come in. Let's see. This is coming from Andrew in Cleveland. Andrew's a paralegal at the Legal Aid Society of Cleveland, very interested in this work and wants to know if there's a role for paralegals or other non-attorneys in this work.
Absolutely. So I've seen many offices utilize the assistance of paralegals in record clearance and in education advocacy work, helping determine whether a young person's eligible for record clearance, helping a young person with their education issues. So you don't have to be a lawyer to advocate for a young person in education proceedings, as long as it's not a court proceeding. When you're at the school and challenging the exclusion of the young person from school, you do not have to be an attorney to do that. So we can absolutely utilize the skills of paralegals to assist in those works.
And just to add to that, in addition to paralegals, we at Legal Aid have relied on interdisciplinary partnerships with social workers and case managers and community organizers and youth advocates. And all of those can be housed within a defender office or a civil legal aid organization, and they can all further the goals of some of what we're calling civil legal areas, but are really civil legal needs that need to be addressed in an interdisciplinary way.
Thank you. And Andrew, thank you for that really great question. I appreciate it. I also want to thank everyone for tuning in today. I'll remind you, you can read more about this, much more in detail in Serena's article that she wrote with Hilella Simpson. That's Collateral Consequences of Juvenile Court Involvement, an Opportunity for Partnership. We've heard a lot about those great partnerships today. You can find the article at povertylaw.org/clearinghouse. If you enjoyed today's conversation, I'll invite you to join our mailing list at connect.povertylaw.org/clearinghouse. You can make sure then that you're notified of future publications and advocacy exchanges. I'd also like to invite you to take our Clearinghouse Community Survey. We do this once a year. It's our chance to hear from you about what it is that we do that's useful for your work and what you need more of. And at the end of the survey, you can even enter to win prizes. If you refer colleagues to the survey, they can also enter your name for still another prize. So you can go to surveymonkey.com/r/SXWC35Y, and that link will be in the follow-up email, so you don't have to scramble to remember that. And lastly, I would like to invite you to join us for next month's Advocacy Exchange. We'll discuss what is, as of now, a leaked proposed federal rule that threatens access to basic needs for millions of immigrant families. I'll talk with Madison Hardy of the Center for Law and Social Policy, Sonia Schwartz, a consultant for the National Immigration Law Center, and my Shriver Center colleague, Gavin Carney, about what this rule would mean and what legal advocates can do to oppose it. Our conversation will take place on Wednesday, May 23rd, same time as today, 1 o'clock Eastern and 10 o'clock Pacific. And we hope that you'll join us next month. And remember until then that you're not alone out there. Thank you.